Good morning, everybody. Welcome to TGIF Trade Geeks. It's Friday. Today is February 27th, 2026, and we haven't done a lot of these videos here lately, so I'm trying to do some catch up. I think there's a lot of notable stuff going on. You know, the big one is the Supreme Court decision, basically repealing the IEEPA tariffs. So the IEEPA tariffs have been ruled by the Supreme Court as being illegal, basically, saying that the president didn't have the powers, sufficient powers anyway, to implement them. So what do we have now? Immediately the president did throw a tantrum. He wasn't happy about it. And he came up with some new tariffs, and they're called Section 122 tariffs. So these new Section 122 tariffs, what are they and what are they about? So it's basically another type of power that the president has to deal with the balance of payments or something like that. So basically, it's the same thing as the IEEPA tariffs. Pretty much the guidance that we got from CBP, it's going to function very similar. You know, the same exemptions are allowed if your product qualifies for USMCA, if you use Chapter 98, if you're using the stacking, you know, the stacking rules still apply for destacking or non-stacking of the tariffs. That all applies. So what are the implications of all these changes? So importers have to contend with a lot of different actions, you know. What is the administration going to do next? That's the big question. And the administration has at their disposal a lot of different mechanisms legally, right? They have the 232, which is a Section 232 that is applied now on steel, aluminum, copper tariffs that will remain. 232 on automobiles, 232 on paper products, also the 232 on the chips. And then in addition to that, you know, he still has other frameworks he could apply, such as the 301 for China. You know, that was one that he implemented back in 2018. You know, there's still the Section 201 for anti-dumping, countervailing duties. There's a lot of these other measures that he could use. They're slower to implement and will require other agencies to be involved or other branches of the government to be involved, such as the judicial branch, right, when he works on any anti-dumping or countervailing stuff. And in addition to that, you know, you have to consider the U.S. Trade Representative, what he has at his disposal. You know, at his disposal as a USTR, he's got the 301 that he can wield that sword if he has to, so to speak. So the other big question that we have now is, what is the CIT going to do? You know, we published an article, Austin Powers published an article this week talking about the CIT, the Court of International Trade, and what they might do, and also what they have said. And two of the notable things that they said that we covered in our article were, number one, the CIT court told us, you know, don't worry about liquidation. We can order the liquidation or reliquidation of any entries, even if they go past the 180 days. And then the second thing that they said is that they would be telling customs, and they had the power to tell customs or CBP exactly what to do and how to handle the refunds. So the big question is, how will the refunds be handled? Don't forget to check out our articles. So one of the greatest impacts that we've seen to this new IEEPA repeal, or that the IEEPA are not, you know, applied, is for foreign trade zones. You know, all for our foreign trade zone customers, we've had problems retroactively eliminating the IEEPA from any withdrawals from the foreign trade zones after February 24th of 2026. So, you know, that's a big thing there. We'll have to watch, see how we're going to manage those refunds. And just to add a little bit of a historical perspective, you know, today we have 900 companies suing now over these IEEPA tariffs, right? Everybody's been getting on this lawsuit bandwagon. And, you know, if we look at a historical perspective, why are companies doing that? You know, why are the legal community recommending that? Basically, we can go back to 1998. You know, we had something similar happen with the harbor maintenance fee. It was a fee that was applied to exports from the U.S. to other countries. It was a fee that exporters had to pay to the government. Basically, there was, you know, also some lawsuits involved with that. and the plaintiffs won. The lawsuits won, and the people that were suing were able to get their money back. But I think the big difference between, what we saw in 1998 with the harbor maintenance fee lawsuits and litigation and what we're seeing today with the IEEPA is that the exports were not tied to a specific customs transactions like these IEEPA tariffs. These IEEPA tariffs are specific to a U.S. customs entry, right, or a specific transaction, which I think that's a very different from the harbor maintenance case. Okay. So, one of the biggest disruptors that we got to keep on our radar, guys, is the USMCA sunset review. It's going to be reviewed in June. We don't know what the conclusion of that is. If the administration has their way, I think they'll try to pull out of that agreement and get out of a trilateral agreement to remove Canada and isolate Mexico and Canada and do bilateral agreements. That is if the administration has their way. But as we're seeing now, we're seeing there's some pushback now from a congressional level, and also companies are pushing back on all these tariffs that are going on. So the overriding goal right now to all the companies out there is, how are we going to get our money back? Show me the money, right? So we'll have to see. Hopefully the CIT in the next week or so, I'm hoping, will give us some guidance on that, or at least delineate how that will work. In the meantime, we're here helping and supporting our customers with these type of things. We're still working with the 232 offsets for the automotive customers. That's going to continue. So there's a lot of refund opportunities out there. Don't forget to reach out to us at www.trade-flex.com. Everybody have a great weekend, and thank you for your time.